The most common questions that I normally get are, first of all, how do you practice immigration law in Ohio? And to that answer, I say, well, we have we're federal law, so we can actually practice anywhere in the United States. But I like to tell people that my father has been practicing immigration law for the past 40 years or so, and he enjoyed a lot of success and still enjoys a lot of success in the field. We lived a very comfortable life, and so there's a market for it in Ohio and of course across the country. The next question I get asked a lot by my friends and family, where are your most clients from? And most assume they're from Latin America, but for me and my practice, that's not necessarily true. Most of my clients are actually from India, and I have a niche of Ghanaians from Western Africa. So those are the common questions that I am asked, but probably not the questions that attorneys who are watching this video will ask. So what I want to do is talk a little bit about how people come to the United States, and then how immigration law interacts with the two most common areas of law and that I get asked about, and that's criminal law, which is now called crimmigration, as our bar has kind of coined the term, and also family law, specifically immigration consequences of divorce. So how do people come to the United States? There's two ways. First, on what's called a non-immigrant visa. A non-immigrant visa is a temporary visa for a temporary time. And the other type is an immigrant visa. Immigrant visa is a fancy way to say a green card. This, of course, enables someone to come to the United States permanently, obtain permanent resident status, which is the first step to U.S. citizenship. So first, a non-immigrant visa. There's several types. There's more than are on the four on the list. However, these are the most relevant and prevalent visas that are used. First is what's called the B1 and B2 visa. That's B as in boy. That's used for business and pleasure. A B1 is also used if there's a humanitarian reason to come to the United States, for example, to obtain medical treatment that cannot be obtained abroad. And the B2 is for your typical tourist that's coming to the United States in order to go to Disneyland, visit a friend, attend a wedding. There's also student visas. Primarily the student visas are the F1 visa and the J1 visa. There's also an M visa, not as prevalent. The F1 is where you get most of your international students. There are also the most typical working visas. Those working visas are the L1. That's for intercompany transferees. For example, a large conglomerate such as Procter & Gamble out of Cincinnati will transfer in a lot of their executives abroad from Europe or Latin America or wherever, and they'll bring in their executives and managers under this program. There's the H-1B visa, which is the most common working visa. The H-1B visa is subject to a quota or a cap. There are 65,000 visas available each year, plus 20,000 extra for graduates of U.S. universities. This year, the government on April 1st received over 233,000 for H-1B working visas for these 85,000 slots. So companies who are planning to bring in workers, and these are all what we call specialty occupation workers, those with a bachelor degree or higher, and the job must require a bachelor's degree, they had a 30% chance to bring their worker into the United States. So as you can see, that's not really a great way to plan your business. H-2B visas are for temporary workers, primarily what we call non-skilled, meaning not having a degree. The prevalent use for H-2B seems to be landscaping field, and also the tourism industry, who if they can show a peak seasonal need, such as a hotel in Florida or a ski resort in Colorado, they use H-2B visas to help bridge the labor gap. E-visas are for investors, and And of course, there's a TN, which is the NAFTA visa for Canadians and Mexicans. There are other types of visas, P visas for athletes, R visas for religious workers, but those are the primary non-immigrant visas. And of course, there's others for journalists and diplomats and whatnot, but these are the most common non-immigrant temporary visas. There's then the immigrant visas. There's certain ways to get a green card. Not everyone can get a green card. However, if you are lucky enough to win the green card lottery, of course, you can obtain the green card, which again, I use the term green card and permanent residence synonymously. The green card is the symbol of permanent resident status. So you can win the lottery and win the green card. There is the labor certification process, which is now known as PERM. And the essence of that is if a company wants to hire a foreign worker, they must go through a labor market test where you have to show that the hiring of this foreign worker will not be taking the job away from a U.S. worker who is willing, able, and qualified. So companies must advertise certain places on websites, in the newspaper, with recruiting firms to show that there is not a willing, able, and qualified worker. If there is, the foreign worker is not qualified and cannot get the green card based on that process. There's also what we like to do a lot in our office called the national interest waiver. If you can show the work that you are doing is in the national interest of the United States, you can get your green card. Cancer researchers, any type of researcher could be qualified for this category. Physicists, again, anything showing the work you are doing and the impact you are making, you may be able to obtain a national interest waiver. The benefit of the national interest waiver is you do not have to go through the arduous labor certification process. There's, of course, the investor category. Many people are aware of the investor category, have read about it. If you invest about $1 million in the United States, you can, what some people say, buy a green card. It's not that easy. It's actually a very tedious process, but it is one way to get a green card. There's also asylum. Many people call it political asylum, but that is just one of the grounds for asylum. For asylum, you must show a well-founded fear of persecution in your home country based on one of the five, enumerated grounds. That would be race, religion, nationality, political opinion, or in a particular social group. That's where we as lawyers have the ability to kind of try to stretch the law to allow and help people flee their home country. And of course, one of the most common ways is the last way and most relevant potentially to our talk today is U.S. citizens and green card holders can sponsor their family members to come to the United States. You can sponsor your spouse, your fiance, your parents, your children, or your brothers and sisters. The process for a spouse, which we call an immediate relative, could take potentially less than a year, 6 to 10 months. However, if you're a U.S. citizen and you're sponsoring your brother and sister, it can take between 10 and 12 years. And if you're from the Philippines, it can take close to 100, and that's not a joke either. So that's the background on immigration law. Now I want to talk a little bit of how immigration law and family law intersect. As I talked a little bit about U.S. citizens many times will sponsor their relatives. Immediate relatives are spouses and children who are defined as children under 21 of U.S. citizens and parents of U.S. citizens. There is no wait to file. There is no line. There is no backlog. These people are not subject to a quota like some of the other categories are. The law states that if you enter the United States legally and you're in the United States, then you can actually what we call adjust your status or obtain your green card in the United States. One of the most important things to understand about immigration law and why our practice seems to help more people who have entered legally is if you enter legally, it means you've been inspected by an immigration officer. You've shown your passport, you've shown an ID, you've come through the border. You didn't, swim across a river or sneak in through a boat. If you enter the United States illegally, the law makes it very, very, very difficult to obtain your green card while in the United States. It almost makes it impossible. And in the illegal immigration debate, that's not brought up a lot. It is very hard, if not close to impossible, to obtain a green card if you enter the United States illegally. Unfortunately, we cannot help many of the people unless they fit very particular categories. So one of the most important things to always ask, did you enter with a visa or without? There's also the fiancé visa. U.S. citizens can bring their fiancés as long as you've met them within the past 2 years in person as opposed to online. You can bring your fiancé to the United States. It's a 2-step process, filing a petition with the government here and then entering the United States. You then have 90 days to get married to that person. So the petitioner must marry his fiancé. The fiancé can't go out and marry someone else. Well, they can marry someone else. However, they will not be able to obtain status through that. But they must get married within 90 days of entering, and then they can apply for adjustment of status. If you file for a spouse, and now I just want to mention that with the Supreme Court striking down DOMA, a spouse now includes same-sex spouses. You can bring your spouse to the United States, or if they're here, they can adjust the status. The process is filing a form, what we call I-130, with the USCIS. The I-130 establishes 2 things. One, you are free to marry, you're divorced or single or widowed. And number 2, you have a valid, real relationship, that you are not marrying someone just to get a green card. If you're in the United States, you can adjust your status. If not, you file the I-130. Hopefully it's then approved, and then you go through what we call consular processing. Consular processing, you have to show as the sponsoring spouse that you can financially support your spouse, and we'll get into what's called the affidavit of support requirements. But you have to show you can sponsor your spouse financially, and that they will not become a public charge. And of course, your spouse has to show eligibility for the visa, meaning they didn't lie before to the U.S. government, that they haven't violated their status, and of course that they're not criminals or terrorists. If your spouse is in the United States, you can adjust your status. Adjustment of status is the process of obtaining the green card while in the United States. Someone who has entered legally and been inspected is allowed to adjust their status, whether they've overstayed their visas or their status for 1 day or 10 years. If you can show proof you've entered the United States and you're married to a U.S. citizen, you can obtain a green card within the United States within about 3 to 6 months. So along with that I-130, which is the petition for your spouse, you can file what's called the I-485, which is your application for adjustment of status. Again, 3 to 6 month time frame, but one important thing is with this adjustment of status, you must file what's called the I-864 affidavit of support, which again shows that you can financially support your spouse and they will not become a public charge in the United States. Now, someone who gets married and obtains their permanent residence through marriage, or if you've been married less than 2 years, you will only obtain what's called a 2-year conditional green card. If you have been married more than 2 years at the time you are approved, then you can get the traditional 10-year or permanent green card. The reason immigration will give a 2-year green card to those married less than 2 years is to try to prevent fraud or find fraud. So if someone slipped through the cracks and then they just got their green card and never saw their spouse ever again, you have to check in with them. And they've been very good at trying to figure out these sham marriages. So what immigration makes you do now is you first obtain this 2-year green card called the conditional green card. Again, all the same rights and privileges as someone else. With a normal green card, you can work, you can travel, and have other benefits. But on the 2-year anniversary of when you obtained your green card, you must file a petition called an I-751 to show you are still married. And so we have to prove you're still married and living together. So we file a very simple petition, but it's the evidence to show you are living as a married couple, which is so important. They like to see a commingling of assets, things like joint bank accounts, credit cards, insurance policies, leases or mortgages, deeds, any commingling of assets. They also like to see pictures, different times and different places. These are all proof of relationship they like to see. Gym memberships, anything that has both your names on it, we provide to immigration. But what happens if the marriage doesn't go as planned? What do you do? Well, if you're the foreign national or non-citizen, the government actually put through case law says you're in a better position if you're divorced than if you're actually together and separated with your spouse. Because only if you are divorced can you file what we call the waiver of the conditional green card, the I-751 requirement, the removing of the condition. So what we tell people is if you're having marital troubles, if there's no reconciliation with your spouse, if you're the foreign national, you're actually in a better position to be divorced than married and separated, because the government will not allow you to file a petition to remove your residence unless you're divorced, unless you file together, or if you can show abuse, that you've been abused by your U.S. citizen spouse. And there's one other waiver which we call the hardship waiver. It's very difficult to obtain, and basically if you can show that it would result in extreme hardship, you can actually file a waiver, but doesn't require that divorce. So if a U.S. citizen is no longer married to the foreign national during this 2-year period, you must file this waiver. If you're no longer married, you can actually file this petition early. It doesn't have to be within that 90-day period. It can actually be filed late. And the burden is on you to prove that when you entered the marriage to your U.S. citizen spouse, you did so in good faith. So much of the evidence that you would normally need is the same thing you would file with a joint petition, such as joint bank accounts, credit cards, leases, and things like that. Without that type of proof, it'll be very difficult to get the conditions removed of your residence and obtain that 10-year green card. Again, other ways to obtain this waiver of the joint filing is if you've been abused, whether it's physically or emotionally, by your U.S. citizen spouse. Of course, the government takes this very, very seriously, so the burden is very high to show this threshold of abuse. Now, when we talked about obtaining the permanent residence, I kept mentioning the affidavit of support. The affidavit of support is necessary in all cases where a spouse, fiance, or other family members bring a foreign national to the United States. Now, there's 2 different kinds of affidavits of support, and the distinctions are very important. There's the numbers relate to the form. The I-134 is an affidavit of support that's primarily used for those non-immigrant visas, for student visas, for sort of fiance visas, depending on the consulate. And the I-864 affidavit of support, which is used for the immigrant visas and the green cards. The distinctions, again, are very important. The I-134 form is not specifically enforceable. It's more akin to what we call a moral promise. I do have on the PowerPoint the language, but I'll read it. I acknowledge and I have read the sponsor and alien liability on page 2, and I am aware of my responsibilities as a sponsor under the Social Security Act as amended. I certify under penalty of perjury that I know the contents of this affidavit are true and accurate. Again, this is a moral obligation. It is very hard to enforce, unlike the I-864, where we'll spend most of the next 15, 20 minutes on talking about the I-864 and how lawyers and immigrants have used the I-864 as a sword, as a means to get spousal support from their U.S. citizen spouses. The I-864 was specifically created so that it would make a contractually binding and enforceable agreement between the sponsor and the intending immigrant, the foreign national. The I-864 can be found online if anyone cares to read it, www.uscis.gov. There's a section for forms, and then you click on the I-864. It's now about a 9-page form with a lot of legalese in it. But I tell my clients the document is a legally binding contract, one signed by the U.S. citizen sponsor. And it does two things. First, it basically says if the foreign national comes to the United States and receives public assistance, let's say $100 in food stamps, the government, whether local or federal, can sue the foreign national to pay them back for that expense. Again, the point is to indemnify the U.S. government, to try to keep not have these resources go to those who are not entitled to it, and they want to prevent these immigrants to become a public charge. That was the specific reason of it. The second reason is it's an agreement that if you sponsor a foreign national, that you agree to, most of the time it's your spouse, to maintain his or her income at 125% of the poverty level. The contract goes into effect if and when the immigrant, the foreign national, obtains the green card and enters the United States. The obligation can go for 10 years. The obligation goes until that foreign national, if and when they become a U.S. citizen. The obligation continues until that foreign national leaves the United States and abandons their green card, or whether the petitioner, U.S. citizen, or the foreign national die. What we've learned is divorce does not terminate the obligation. Therefore, if you divorce your foreign national spouse and you've signed an affidavit of support, and a year later he or she obtains public benefits, the government can sue you to pay them back for that expense. I've been doing immigration law now about 15 years, can't believe that, but have. And I have never had one client call my office, much less hire me, to say, oh my God, the government's trying to enforce this affidavit of support, what do I do? Does it happen? I'm sure it happens. It doesn't happen very often. It's not posted on our American Immigration Lawyers website very often. So the likelihood is small. I don't think the government uses the provision very much, but where we see it more is in the case of divorce from a foreign national. So how's it enforced? It's enforced as part of the statute, 8 U.S.C. 1183. It's enforceable in any court of competent jurisdiction. So basically, you can bring a case in federal court outside of divorce. So basically, any federal court, you can obtain jurisdiction to try to enforce the affidavit of support. So in a divorce proceeding, if you want to obtain spousal support, you can actually sue your spouse or ex-spouse in federal court. It's also enforceable under case law. There's a couple cases here, Nake versus Nake out of New Jersey, a federal case, Cheshire versus Cheshire, and also, I don't know how to say it, Shumye, which is a California case. It's also enforced, the affidavit of supports have been found enforceable in state court. There's Nake out of New Jersey again, and actually Davis versus Davis, which is an Ohio case, where the court specifically found that the foreign national could use the affidavit of support obligations to obtain spousal support. Federal and state courts have recently been called on to address this issue, seeking enforcement of the affidavit of support requirements. What is little known about these enforcement actions in statute and regulations pertaining to the affidavit of support is that the U.S. citizen, in theory, could be liable for life. Divorce, like I said, does not terminate the obligation. And there's debate whether a prenuptial agreement would terminate this obligation. Section 213A of the INA, which is the Immigration and Nationality Act, establishes the legal obligations and enforceability of the affidavit of support that must be submitted in all family-based cases and in certain circumstances for employment-based cases. So if an employer is to sponsor through the labor certification process a close family member, they actually have to execute an affidavit of support. Doesn't happen very often, but it can. When a U.S. citizen marries a foreign national, the U.S. citizen must sponsor his or her spouse as a condition precedent to immigration into and becoming a lawful permanent resident of the United States. The U.S. citizen must execute the affidavit of support requirement to get the sponsorship. So essentially, U.S. citizens are, if you want to bring your spouse here, or fiance, or even children or parents, you must file this affidavit of support. There is no way around it. And again, the purpose is to prevent people coming here to become public charges, but it also, has this very strict obligation that can definitely be enforced. The Form I-864, the Part 8, establishes that the sponsored immigrant's acquisition of lawful permanent resident status is the consideration for the contract. The Form I-864 Part 8 also establishes that the sponsor must provide the sponsored immigrant, that's the foreign national, any support necessary to maintain him or her at an income that is at least 125% of the federal poverty guidelines until the affidavit of support terminates under one of the conditions. Like I said, the conditions for termination are death to either party, if the foreign national becomes a U.S. citizen, or they can be accredited with 40 quarters of work in the United States, the affidavit of support obligation will cease to exist, or if the foreign national leaves and abandons their green card, the obligation will terminate. If the sponsor does not provide sufficient support to the person who becomes a permanent resident based on the I-864, that person may sue you for support. That's actually in the I-864. So using the affidavit of support in spousal support cases. As we know, when you bring someone, enter a marriage, sometimes it always doesn't go the way you planned, and things happen and divorce happens. Of course, there's situations of abuse or neglect. And so courts have looked at, how to award support when trying to enforce this affidavit of support. Courts may reject arguments of enforceability under the affidavit of support. For example, if you can't obtain a copy of the I-864, the court may choose not to enforce it. And sometimes the 864s are hard to obtain, even under the FOIA Act, because the I-864 is under the name of the U.S. citizen's spouse. State court also may want to limit its proceedings to matters of state law, or if someone signed just an I-134, then what? So I am not a family law attorney. My practice is limited to just immigration law, but I do know a little bit, very little, about spousal support under state law. So some of the factors under the revised code 3105.18, many of the factors for awarding spousal support are going to be in favor of the foreign national, even if it's just an I-134, which is, remember, the moral obligation. Those factors include, of course, the income of the parties, the relative earning ability of the parties, the ages and physical, mental, and emotional conditions of the parties, the retirement benefit of the parties. Again, this is right from the statute. The relative extent of education of the parties, the relative assets and liabilities of the parties, including and not limited to any court order payments of the parties, the contribution of the parties to education, training, or earning ability, the lost income production capacity of either party that resulted from the party's marital responsibilities. However, under the statute, there are two factors that may cut strongly against an award of support in our state statute. That's the duration of the marriage, which many times for immigrants bringing a spouse or fiancé over can be extremely short, and the standard of living of parties established during the marriage, usually, again, based on a brief marriage. So calculated the actual support amount under the 864. As I mentioned, the courts have said that you must agree to maintain your spouse's income, foreign national spouse's income, at 125% of the poverty level. So where are those poverty guidelines? I have the 2013 here on this PowerPoint because I couldn't figure out how to fix my slide. The 2015 are out. The numbers have only gone up by several $100s. So for a family of two, a husband sponsoring a spouse having a family of two, 125% of the poverty guidelines are $19,387. I think that number is up to about $19,900 for the 2015 guidelines. These guidelines are determined, I believe, by the Department of Health and Human Services and are published every year. So calculating the amount of actual support under the 864. Based on the numbers, again, for a family, let me go back, family of two, it's about $20,000, a family of three, $25,000, family of four, $30,000, and the numbers go up from there. But this is actually a pretty small amount. After the award of support, that doesn't take into consideration taxes, income tax. So many creative attorneys have made an argument, can't the foreign national leverage the I-864 to obtain a net level of support at 125% of the poverty guideline? And the answer to that, at least in Ohio, has been no. There's a very important case, which citation is now up on the screen, Nasir versus Shaw, which was decided a few years ago here in Ohio. A very, very important case in Ohio about the enforceability of the I-864. Essentially, the court held that there's no net level of support. Some of the language in the case is very, very interesting. This, again, the background of this case is a U.S. citizen sponsored his foreign national spouse, came to the United States, obviously got married, obtained the green card, and shortly thereafter, marriage didn't work out, became a very ugly divorce, and the foreign national spouse started using this affidavit of support as a sword, as a means to get spousal support. The creative attorney in this case wanted to obtain a net gain of that 125% of the poverty guideline. The court said, because the plaintiff has debts which he must pay, he believes that he is entitled to money to offset those debts in addition to the amount equaling of 125% of the poverty guideline. This is a fundamental misunderstanding of the statute. The court said the plaintiff is not entitled to a sum of money that equals 125% of the poverty level after taking into account debts and loans. The purpose of the statute is not to provide the sponsored alien's financial security or to enable him to incur debt and pay it back. The purpose of the statute is to ensure that the legal residents do not have to depend on public benefits for their support. And that's coming from the regulation 8 CFR 213A2C2. Plaintiff is entitled to be maintained at 125% of the poverty level and no more. The plaintiff in that case also argued he's entitled to support for his educational debt because the statute provides that he's entitled to at least 125% of the poverty level. And unfortunately, or fortunately, depending on which side you are, the court said there's no case law supporting that position. The literal language of the statute binds a person petitioning the admission of a family-sponsored immigrant to provide support in the amount of 125% of the poverty level. The petitioner may provide more support than that, but in line with the statutory purpose to avoid the alien becoming a public charge, the additional money does not reduce his support obligation for succeeding years. Again, in this case, the attorney was very creative, the plaintiff's attorney, and said, well, what if the foreign national is financially abused while living in the household? The Nasir court also addressed this issue. In this case, the plaintiff's assertion he was abused financially is irrelevant, the court found. The plaintiff complains that he was forced to pay rent when he and his wife stayed with her parents. Plaintiff was also forced to make payments on his wife's student loans and credit cards with his money. The fact remains that in 2009, the household was supported at income far surpassing the 125% of the poverty level guidelines. Disagreements of how the household income was allocated is beyond the scope of the I-864 contract and irrelevant to the plaintiff's claim. So that's, again, the Nasir case. All attorneys should look at. Shepherd-Eyes, Keysight, I don't know what people call it anymore, to make sure that they're updated on this Nasir case if you are representing the foreign national or representing a U.S. citizen. There are also other approaches to this. Basically, courts have found that support under the affidavit of support, there is an obligation for the foreign national to mitigate, give the sponsoring spouse offsets for any amount that foreign national actually earns. Basically, the sponsor would be required to make up the difference. So if the foreign national made $10,000 a year and the poverty guideline was $20,000, then the U.S. citizen would be on the hook, of course, for about $10,000. That's the Shumay court and the Cheshire court. In Cheshire, the court held that a student grant would be counted towards the income of the foreign national, but a student loan would not be because that had to be paid back. Also, the court found that monetary settlements from property issues in the divorce, such as an equity buyout, do not count as income. So again, these are just different ways to figure out how much of support, depending on which side of it on your client will be entitled to. In the Nasir case, the court counted the foreign national's unemployment compensation as payments as part of the offsetting income. So whatever those amount was, minus the 125% would be the amount the U.S. citizen would be entitled to. And again, in that Nasir court, the court also declined the foreign national's request for an order of monthly maintenance. The court held that plaintiff's request for an order of monthly maintenance is denied. The plaintiff claim for financial support for 2013, again, this was a 2012 case, is premature. The amount of money defendants may owe plaintiff, if any, is uncertain. Plaintiff continues to seek employment, and it's unclear how much income he will receive in 2013. If Nasir's income in 2013 exceeds the 125% of the poverty level, defendants will have no support obligation at all. If Nasir's income falls below that level, defendants will be obligated to pay the difference. So in this case, the court rejected the monthly maintenance. So again, calculating duration of the obligation, as I mentioned before, the affidavit of support goes into effect if and when the foreign national obtains permanent residence status or the green card. They're synonymous. If the foreign national naturalizes, becomes a U.S. citizen, the obligation ends. If the foreign national acquires or has acquired 40 qualifying quarters under the Social Security Act, the obligation ends. If, again, each die, the obligation, of course, ends. So defenses. So that's how attorneys have used the affidavit of support as a sword. But what are the defenses to the I-864? Can your foreign national spouse waive a claim for support under Ohio Revised Code 3105.18 in state court? And if they waive it under this section in state court, can the foreign national still sue the U.S. citizen for breach in federal court? And the Nasir court said yes. In this case, the foreign national filed an I-864 suit in federal court 3 weeks before the trial of his divorce, where he waived his claim for support under the Ohio Revised Code. And they proceeded to trial on other issues. The federal suit said basically it could go on, and the court rejected the U.S. citizen's res judicata defense and said no, the statute specifically says that the foreign national can pursue this claim in federal court, and they cannot waive just based on the waiver in the state court. But what if the foreign national fails to mitigate damages? This affirmative defense has been recognized by numerous courts. There's the Stump versus Stump case from 2005, which stated that there's no body of federal common law specifically addressing the issue. The court noted that the general duty to mitigate damages is a basic tenet of contract law. Applying those principles, it is found that any funds the plaintiff, usually the foreign national, has received after her separation should be subtracted from the amount the defendant, usually the U.S. citizen, must provide to maintain the plaintiff at 125% of the poverty level. Other cases have gone on to hold the same thing. Again, you can notice that these are federal cases. There is an obligation to make reasonable efforts to find employment and mitigate damages. Came out of Maryland. In short, the sponsored immigrant is expected to engage in gainful employment, training in accordance with common law to duty to mitigate. Love versus Love said the court acknowledges the foreign national's wife has a common law duty to mitigate. However, only one federal court of appeals has addressed the issue, and again, it says we can't see much benefit to the imposing a duty to mitigate on a sponsored immigrant. The cost, besides the sponsor's diminished incentive to screen the alien for a bad work ethic, would be the increased complication of enforcing the duty of support by giving the sponsor a defense, and not even a defense likely to prevail. So the Seventh Circuit actually indicated that there was not a duty to mitigate. I see there's a question from
Yes.
the audience.
Yes. Here's the question. Does the I-864 have any bearing on calculating child support?
Good question. I believe it's limited to spousal support. The duty, however, I assume child support, well, I guess there are again, it depends on how we talk about child support, but if an immigrant sponsors, for example, a stepchild, they must file an I-864 for that stepchild, and I do believe that stepchild could bring an enforcement action to obtain support under the terms of the I-864. But my understanding, it is only towards spousal support, not child support. So if a U.S. citizen child was born of the marriage broke up, I do not think that calculation would go into the child support calculations. I don't know if there'll be any follow-up, but happy to email me. My email's up there, or will be at the end, and I'm happy to talk about that a little more. Other defenses to the I-864, fraud in inception of the marriage. Many times foreign nationals will lie about their intent, enter into what's called a sham marriage, a fake marriage, a marriage just for immigration purposes. And if you can show that there was fraud in the inception of the marriage, it may be a good argument to get out of your I-864 argument. There's also the doctrine of unclean hands, which provides that a party seeking redress pursuant to the I-864 must have not done an unlawful act. For example, entering into a sham marriage or using the U.S. citizen or duping the U.S. citizen into marrying them so they can obtain a green card. There's always the question, and what I advise my colleagues is, but the question remains out there, what does a prenuptial agreement do? There's a couple different federal cases which has addressed it. I recommend the prenuptial agreement. It'll at least have some basis to help the U.S. citizen. Whether or not, again, the court will enforce it will be up to how it was drafted and all the, if they were under duress, all the normal prenuptial guidelines. I do not think the obligation to pay the government back, if you obtain the welfare benefits, the government will never let that go and prenup that out, but potentially the spousal support argument and will prenup eliminate that obligation. We don't know exactly yet. Some federal courts have weighed in on the prenuptial. Previously in the case on the screen, Blaine versus Harrell, Hawaii District Court concluded that a premarital agreement could waive the beneficiary's rights to enforce the I-864 on the reasoning that the beneficiary was entitled to bargain away her own private rights if she chose. In the more recent case, Erler versus Erler, the parties entered into a premarital agreement stating neither party shall seek or obtain any form of alimony or support from the other. When the immigrant brought a contract action on the I-864 to enforce the agreement, the sponsor sought to go for summary judgment, arguing that the premarital agreement rendered the I-864 void. The court rejected this argument on two grounds. First, the court held that the premarital agreement could not waive rights under the I-864 as the agreement was executed before the I-864. These facts distinguished the Blaine versus Harrell case in which the premarital agreement was executed after the I-864. Second, this court held that the defendant sponsor could not unilaterally absolve himself of the contractual obligations with the government by contracting with the third party. The reasoning fundamentally departs from the Blaine versus Harrell, where the court reasoned that a beneficiary private rights were her own to waive if she chose. Indeed, the U.S. Department of Homeland Security itself has opined that the beneficiary may elect to waive her rights under the I-864. So I advise doing the prenuptial agreement as a way to try to I tell my colleagues to specifically try to put a clause in there to waive the spousal contractual rights under the I-864, and then it will give your client a better position with the court to try to enforce or have an affirmative defense against a suit brought on the I-864, and then it's up to a court to decide. I'm not aware of a court case in Ohio that's addressed the prenuptial defense. I'm sure there could be something out there. I'm just unaware of it. So that's going to bring me to the end of talking about family law in the intersection, and now I'm going to talk about what we call now crimination. The most frequent call I get to my office are from colleagues who are criminal attorneys who are saying, "Oh, I got a client. He's from France. He just got arrested for drug possession. What do I do?" So there's three things you need to know. How am I doing on time? Okay. All right. Again, thanks everyone for staying late with me. So what do you need to know? Someone comes into your office, you obviously need to know their immigration status. Are they here on a non-immigrant visa? Do they have a green card, which means they're a permanent resident? Or, of course, if they're a U.S. citizen. You obviously, with any case, need to know their prior criminal history. And, of course, you need to figure out what charges they have pending against them. Now, in immigration law, I usually start off most of my talks by talking about how, we think it's one of the most complicated laws, areas of law in our jurisprudence system, mostly because we deal with the federal government every day and the challenges that come with that, Others because we're dealing with people from other cultures who don't like to tell the truth or are scared of persecution by the police from their home countries. So it's a very, very difficult field. At any one time, we deal with almost 6 government agencies. Of course, the U.S. Department of Homeland Security, and the 3 agencies we deal with are United States Citizenship and Immigration Services, USCIS, who gives the benefits like the green cards, the Immigration and Customs Enforcement, who are the immigration police, who arrest the foreign nationals for committing crimes or status violations, and of course Customs and Border Protection, who are in charge of securing the border. Now, there's 2 very important distinctions which you have to understand in immigration law, which is called inadmissibility versus deportability. Inadmissibility can be found, the laws under 8 U.S.C. 1182 and deportability under 8 U.S.C. 1227. Inadmissibility has to do with you knocking at the door. Imagine coming to the border or applying for a green card. The laws of inadmissibility apply. Once you're in the United States, whether legally or illegally, the laws of deportability apply. And actually, the criminal consequences of both, there are differences. Regardless, and most of the time, in order to have an immigration consequence, you must need a conviction. A conviction is defined as a finding of guilt or admission of sufficient facts, and the judge has ordered some sort of punishment, penalty, or restraint on the alien's liberty to be imposed. Juvenile convictions in general do not count for immigration purposes. A youthful offender adjudication may be a conviction. In immigration law, you don't even have to be convicted of a crime to have an adverse immigration consequence. If the government has a reason to believe you are a drug trafficker, a reason to believe you are a drug abuser or addict. There are certain other violations for asylees, engaging in prostitution, or even discretionary decisions. There can be adverse immigration consequences. Now, in my 1-hour speech today, there's so much to cover under criminal immigration. There's so much to cover under the family law. I'm trying to just highlight all of it. I'm sure the Bar Association will have many other seminars that dig deeper into the crimination issues. I know for a fact they will. Under immigration law, a sentence includes any term of incarceration, whether committed or suspended. An example, if you get a 2-year sentence of imprisonment, 6 months to serve, and the balance suspended for a year, that equals a 2-year sentence of imprisonment. Frequent question I get is, hey Neil, is this a crime of moral turpitude? And the answer I usually say is, I don't know. I don't know what a crime of moral turpitude is. The courts don't really know what a crime of moral turpitude is, but they've tried to, we've tried to make this easy equation that there has to be, if there's a criminal intent and reprehensible conduct, it's probably a crime of moral turpitude. The seminal case on the issue at this point is an immigration case called Matter of Sevilla Trevino, and the citation, that's a Board of Immigration Appeals citation. Everyone should take a look at it. Different crimes of moral turpitude. There can be crimes against a person, murder, manslaughter, sexual offenses, and of course crimes against property, arson, robbery, or any type of theft, including shoplifting, can be considered a crime of moral turpitude. So the types of consequences, if you're convicted of a crime, it can result in removal from the United States, denial of a green card, permanent bars to U.S. citizenship, loss of a visa, denial of asylum, and other adverse consequences are inability to apply for immigration waivers. So again, it's really important to understand the difference between inadmissibility, knocking at the door of the United States, and deportability, where basically they're trying to throw you out that door. The inadmissibility crimes, you can be deported for crimes of moral turpitude, controlled substance violations, prostitution, or any conviction of multiple offenses where the aggregate sentence is 5 years or more. You can be deported for crimes of moral turpitude, drugs, any gun offense, domestic violence, though in Ohio that's debatable, and what we call aggravated felonies. An aggravated felony has nothing to do with the criminal term felony. It's a term of art under immigration law. There are misdemeanors where actually considered aggravated felonies. So many times, again, we have someone call our office. I just had a client picked up for shoplifting in Ohio. This is probably, shoplifting is considered a crime of moral turpitude, but most shoplifting charges do fall under what we call the petty offense exemption. A person is inadmissible based on one crime of moral turpitude unless he was under 18 years before admission, and the maximum penalty is 1 year or more, and the sentence is 6 months or less. So that's, if you're a criminal attorney out there, you always want to strive to make the client convicted, if he has to be convicted, of something that will fall under the petty offense exemption. Like I said, I got to kind of hustle through these, but drugs are a violation, and this includes paraphernalia. So if someone gets caught with a crack pipe, a marijuana pipe, that could lead to have both deportability issues and admissibility issues. Prostitution. If to be a John, you're actually okay. If you are a prostitute or a pimp, or procuring someone for prostitution, it can render you both inadmissible and deportable. Multiple offenses. 2 or more convictions, which aggregate sentence is 5 years or more, you can be found inadmissible to the United States. Now, some deportable offenses. 1 crime of moral turpitude within the 5 years of entering the United States where the sentence of 1 year or more may be imposed will be considered a crime of turpitude. Please notice the word may. So even if you're convicted of or sentenced to something less, if you could have been sentenced to 1 year or more, it may be considered a crime of moral turpitude and a deportable offense. Drug offenses and deportability. Any drug offense, including paraphernalia possession, can result in deportability. There is one exception to the grounds of deportability, and that's 30 grams or less of marijuana. And it includes, again, conspiracy or attempt. Pretty much any gun charge you have is going to result in deportation, so we recommend trying to plea down or away from any sort of gun charge. Domestic violence is an interesting issue. In general, domestic violence is what we call a deportable crime. However, in Ohio, the statute 2919.25a in immigration context has not been considered a deportable offense because based on the statute, it is not a crime of violence, which must be part of the statute because of the whole physical force versus physical harm issue. Again, this is a great debate and can probably be looked at a different seminar. Aggravated felonies are the worst of the worst: the murder, rape, crimes of violence with sentence of 1 year or more to be avoided at all costs. It's basically a one-way ticket out the door with no way to ever come back. Automatic deportation and mandatory detention. So we're going to run through that. Again, common aggravated felonies: rape, murder, crimes of violence, theft offenses of more than $10,000 can be considered aggravated felonies. I want to touch a little bit on DUI. The Supreme Court case of Leocal versus Ashcroft in 2004 held that DUI was not a crime of violence and therefore was not an aggravated felony under the INA warranting deportation. This was the result despite the fact the non-citizen was sentenced to imprisonment of more than 365 days. If you have a client with multiple DUIs, this will be a problem to obtain U.S. citizenship. But DUI can be considered a crime of moral turpitude if there are aggravating factors, such as driving on a suspended license or hurting someone. It can be considered a crime of moral turpitude, which will bring us into some of the crime of moral turpitude analysis. So again, we have some charts of how to analyze the individual consequences. Does it fall into any of the categories of admissibility or deportability, your client's status, immigration status, your client's former record? Determine how your client's charges, immigration history, and prior record impact the analysis, and determine your client's priorities. Is their priority to stay out of jail or remain in the United States? There are post-conviction relief options, motions for new trial, motions to vacate pleas. Everyone should be aware of the Padilla versus Kentucky Supreme Court case, which basically says criminal defense and all attorneys have a duty to find out the immigration consequences before advising their clients of a plea. Although Padilla recently has been found, well, a couple years ago now, have been found not to be retroactive, so the duty starts in 2010 and goes forward. One more thing is, in Ohio, we're lucky enough to have an immigration warning statute, ORC 2943. I'll give a shout out to my dad. My dad was instrumental in passing that law in 1989. Good job, Dad, if you're listening, or probably asleep by now. But good job in that. So again, the last thing in this crimmigration, always talk to an immigration attorney. Don't assume you know what a crime of moral turpitude is or an aggravated felony. Talk to your client about their goals. At all costs, avoid aggravated felony convictions. Tell your client or yourself to talk to an immigration lawyer and get help analyzing the immigration consequences of the crimes. So that's all I have. I think I may be out of time anyway. I ran through the crimination stuff pretty quickly. We promise another seminar here at the bar shortly on that if we want. I'm happy to take questions. Feel free to email me. It is USA.com. Someone, whether it's me or my office, can't type. Immigrate2USA.com. Please email me at neil@immigrate2USA.com or through the bar. Thanks for having me.